Welcome, viewers, to Part 3 of the 25th Annual Autumn Estate Planning Seminar brought to you by Chipman, Mizuko, Emerson, a Danbury and Southbury, Connecticut law firm. My name is Richard Land. I'm here to introduce you to Alyson Marcucio, who's presenting Part 3 of the seminar, which is devoted to the 5 most frequently asked questions about elder law. Alyson is picking up where the presentation in Part 2 left off, so here she is in Part 3.
So like Rich said, I'm going to just talk about the 5 most frequently asked elder law questions. And I'm not going to get into any great detail about any one question, but I just kind of wanted to touch on some of the key points that come up with respect to each of these questions. The first question has to do with nursing home admissions agreements and liability that somebody could potentially take on if they're signing as a responsible party. So I get a lot of phone calls from mostly children or sometimes spouses, but mostly children who have been asked by a nursing home to sign an admissions agreement for their parent who's a resident at a nursing home. And they're asked to sign it because they're power of attorney for one of their parents. And you have to just keep in mind that even if you're a power of attorney and acting for your parent under power of attorney, you need to be very careful how you sign a nursing home admissions agreement. There's a lot of different lines on the admissions agreements. There's the resident line, which is typically the line your parents would be signing or your loved one would be signing if they get signed for themselves. There's a line often for a responsible party. There's lines sometimes for power of attorney or a conservator. So the most important thing to keep in mind is, if at all possible, the resident themselves should sign that paperwork. So if it's your parent or your spouse or another relative, or even if it's just a friend or a neighbor that you're there with helping them get admitted to a nursing home, if they could sign that paperwork for themselves, then they should sign it for themselves and sign all the other accompanying paperwork. If you're signing as power of attorney, often, again, as I mentioned, the facility is asking that you're signing as a responsible party. So you ask, well, what exactly does it mean if you're signing as a responsible party? Are you taking on financial responsibility? Are you taking on other responsibilities? And that's where you really have to take a look at the actual agreement and see what responsibilities you're taking on if you do indeed sign on behalf of your loved one. You don't have to feel pressured to sign the agreement immediately upon admission. You could ask the admissions department if you could take the agreement home with you. If at all possible, it's a good idea to have it reviewed by an attorney like myself to make sure that you're signing it properly. But again, don't feel pressured that you have to sign it on the spot. It's not like, signing, if you don't sign on that line, you can't take the car home that you're purchasing. You want to make sure that you understand what you're signing and take the time to read through that agreement. Connecticut in federal law prohibits nursing homes from requiring you to guarantee payment of a person's nursing home costs. They can't require you to sign as a responsible party. And also, a family member can't be refused admission for your refusing to sign. But, oftentimes you feel like you're in a spot because either the hospital is looking to discharge your loved one to a nursing home, and either facility has a bed or doesn't have a bed, and you feel like if you don't sign that paperwork right away, then your loved one's not going to have a place to go. Again, that's not necessarily the case. There have been cases in Connecticut where the responsible party, so if you decide to sign on as a responsible party, there's been cases in Connecticut where the responsible party is sued by a nursing home for a breach of contract. So for example, in reading through these admissions agreements, one of the provisions is often the obligation by the responsible party to apply for Medicaid to help pay for the resident's care in the facility. So for example, if your loved one doesn't have enough money to private pay for that nursing home cost, then they might need to apply for Medicaid to help pay for that cost. So the agreement might say that you, as responsible party, if you've signed as responsible party, have to apply for Medicaid and have to provide the required documentation to the state of Connecticut Department of Social Services within a reasonable time frame. And if you unreasonably delay the application for Medicaid, then that's a breach of contract and you could be sued. So while you might not have a financial obligation to the nursing home, there might be other obligations, and you definitely don't want to be sued for a breach of a contract, for example. Another provision to watch out for in admissions agreements are binding arbitration clauses. The signing of a binding arbitration provision in a nursing home agreement is not an obligation, it's optional. If you sign it, then you're giving up your right to resolve a nursing home dispute in court. So you might not want to give up that right. You don't necessarily want to rely on the nursing home representative's explanation of what the agreement contains. You definitely want to read it for yourself, or again, ask an attorney to review it, so you know for yourself what you're agreeing to sign. Because unfortunately, a lot of times the nursing home representative may not know exactly what the agreement says or what some of the terms of the agreement say. So you want to know for yourself what obligations and liabilities you're taking on. If you need to cross out some provisions in that agreement, you certainly can do so. Sometimes nursing homes aren't quick to accept some of those omissions, but at least if you cross them out, it starts a discussion about what your concerns are and how you might reduce liability that you might otherwise be taking on. And then finally, with respect to these admissions agreements, if you do end up signing the agreement, you should be sure you're signing in your capacity as power of attorney. For example, you would sign on the residence line. So not necessarily the power of attorney line that they might supply for you. You don't want to sign on the responsible party line, but rather you want to sign on the resident line. And one way to sign is you're signing your loved one's name, and then you print the words followed by the word by, and then you sign your own name, followed by the words power of attorney or attorney in fact or agent. So then you're showing and you're giving a clear indication that you're signing that agreement in your capacity as power of attorney for that resident. Before I turn over to the next question, does anybody have any questions or comments about the agreements?
Well, I was just wondering, as a minimum, somebody signs as responsible party.
Right.
What obligations are they actually taking on? Let's say it's the type of agreement that no overreaching involved at all. It's just that you're signing as responsible party, and what typically would that mean that party has to deal with and could be held liable for?
So you're talking about it's not overreaching in that the nursing home is not looking for financial guarantee, but rather other obligations. Right. Okay. So again, as I mentioned, it may be the case that if the person can't private pay and it's looking for a Medicaid source of payment, then as responsible party, you have the obligation to apply for Medicaid oftentimes when the person is down below a certain asset limit, for example, $50,000 in assets. So if you fail to do that as a responsible party, it's a breach of contract, so you could be sued. Whether or not the nursing home will take action right away, that's one thing, but you certainly don't want to take that chance. So it's really breach of contract actions that you run the risk of
So
taking on.
you really are exposed to some real liability.
Yeah, absolutely.
Nobody should ever come close to signing that on that line.
Not on a responsible party line. No, no. Definitely could take on some responsibility and liability. And even in the agreements, oftentimes it says, you know, that you agree to, as a responsible party, you agree to make payment of the nursing home costs. I always write in there from the residents' funds. So even though there's not a financial obligation or financial guarantee, I want to spell it out to make sure it's clear where that money is coming from.
Do these same kind of rules apply for places like assisted living facilities, life care facilities, particularly with the arbitration clause and that sort of thing?
Yeah, they do. So I certainly have reviewed a number of assisted living admissions agreements also, and err on the side of caution. They don't have as much of that responsible party language in the assisted living agreements, but I still err on the side of caution because, again, you just don't want to be taking on any responsibilities that you ordinarily wouldn't have taken on. All right, so I'm going to turn over to question number 2, which has to do with caregiver child who's providing some care for their parent. Often I get the question of whether or not, as a caregiver child, and let's say I'm the caregiver child, can I get paid when I'm providing care for my parent? And the short answer is, well, yes, you can, as long as you're a caregiver child. You can't be a stepchild. It has to be a blood relationship. You have to actually be providing some care for your family member. The care and the payment has to be pursuant to a written care agreement that you enter into, not retroactively. Pay can't be retroactive, but has to be current. So if I enter into a care agreement between myself as caregiver child with my parent, I cannot now get paid for care I might have been providing 6 months ago. That payment must be going forward from the time the care agreement is entered into. So we can't have any lump sum payments. So if I'm providing assistance to my parent with things like, you know, activities of daily living, bathing, dressing, toileting, transferring, driving them to the doctor's offices, things like that, I certainly can get paid under this care agreement, but it has to be on a regular basis. So you have to think of it as if you were hiring an outside agency to provide care and assistance to your parent. You wouldn't be paying them going backwards necessarily, maybe a week or two, because maybe, you know, you're paying this week for time from a week ago, but you certainly don't want to go beyond, you know, a couple weeks of not paying, you know, in retroactive pay. And also, in addition to the written care agreement, you want to make sure that you, as the caregiver child, are keeping a record of the time and the type of care and assistance that you're providing to your parent. And finally, the amount that you're getting paid under that care agreement needs to be tied in with the going rates of what you would be paying an outside care agency. So when you're doing these written care agreements, the current rates are put into the agreement so that we know what the rates you're going to get paid under and what the caps are. So there's a daily cap on what you can get paid, again, tied in with what the going rates are for an outside care agency. And then if there's increases year to year in those rates, you don't have to do a new care agreement. It's just under the understanding that in the current agreement, it's based on the rates as of, and I typically reference it as a footnote of what I based the existing rates on, and then understanding that with increase in those rates, you could charge increasing rates in years going forward. One of the other questions, and Jim, you touched on this a little bit, has to do with the transfer of your primary residence to a child, for example. And there's a number of implications that you have to consider before you transfer, or you should consider before you transfer your primary residence to a child or to children. And I'm just going to touch on them briefly in the interest of time. But the most important thing to remember is if you are considering a transfer of your residence or your primary residence to a child or to children, you should definitely speak to an attorney about the implications and how those implications would relate to your particular case. So first and foremost, if you're going to transfer your primary residence to your child, you want to make sure that you're retaining the legal right to continue to live in your house. So for example, you want to retain the life use, the right to live in your house for the rest of your life, or as long as you want to continue to live in that house. If you're transferring your house to your children, and what you're transferring is the remainder interest in your house, and you would be retaining life use in the house. So you don't have necessarily any protection against your children's creditors. So you want to be very careful. You might want to use an irrevocable trust, which again, I'm not going to get into great detail about, but you might utilize an irrevocable trust instead of an outright transfer to your kids in order to give you some creditor protection against your children's creditors. For example, in the event of a bankruptcy, a divorce, or a lawsuit that your child or children may be faced with. If you retain life use of the property, in most cases, you're going to still continue to pay the real estate expenses, the taxes, insurance, and utilities, unless there's some other agreement to the contrary. You can sell the house, but again, because you've given up some control of the house and complete ownership of the house, if you transfer your house to your children, before you sell the house, their kids have to agree, because you don't own 100% of the house anymore. So there may be a downside to transferring, because you may not want to have to rely on your children's input as to whether or not you're going to be able to sell your house. You're not going to be eligible to apply for Medicaid or Title 19 if you transfer your house to your children or to other individuals for 5 years from the date of that transfer. So you have to make sure that you are in need of care, or your spouse is in need of care, whether that's long-term care in a facility or home care. Because if you make that transfer and you don't have any other assets to pay for your care privately, you're not going to be eligible to apply for public benefits, Medicaid, Title 19 to help pay for that care. At death, the home would pass to the remainder beneficiaries, so that life use kind of dies with you. And currently, under Connecticut law, the state of Connecticut doesn't have a recovery right against the residents that you have retained life use, because that life use dies with you. So Connecticut currently, there's only a recovery. This is in the event you are on Medicaid or receiving Medicaid benefits during your life. Upon death, since there's no probate asset in the house anymore, the state of Connecticut can't recover currently against the value of that house, because again, that life use dies with you. There could be gift tax consequences. You might have to file a gift tax return when you transfer your residence to your children. There may not be any gift tax that's due. However, you may have to file a gift tax return just to report the value of that transfer. As Jim spoke of earlier, capital gains tax, depending on how you make that transfer, there may be capital gains tax implications if later on the house is sold and you haven't retained certain rights with respect to that house. So there could be capital gains tax implications in the transfer of that real estate. And income tax, there's not really any income tax consequences other than the capital gains tax consequences of transferring your house. So again, I just touched really briefly in the interest in time over a number of different considerations in, making a transfer of your primary residence to your children or to a child. It's just very important to not take that decision lightly, and to consider and speak to an attorney about what your particular facts are, to be sure that that you're still protecting yourself in the event you need to apply for Medicaid to help pay for your care. I briefly touched on the next question, and the next question has to do with the 5-year Medicaid look back period. And as I said before, with a transfer of your real estate, there's a 5-year look back period. So I'm often asked the question of, what exactly is that 5-year Medicaid look back period? The general rule is you're not going to be eligible for Medicaid or Title 19 if you've transferred or given away any asset for less than fair market value. It could be a bank account, it could be real estate, it could be a car, within 5 years from the date you transfer that particular asset or account. So if you've given away an asset and you haven't gotten through 5 years, you're not going to be eligible to apply for Medicaid if the time comes when you need either long-term care in a nursing home or home care. So you have to be very careful when making any gifts, and that could include even what people often refer to as your annual exclusion gift. It's $15,000 a year under the current law. If you make any gifts within that 5-year look back period, so within 5 years of you needing to apply for Medicaid, you or your spouse may not be eligible to apply for Medicaid. There are some exceptions to the transfer rules. If you've made any transfers between you and your spouse, you could transfer assets back and forth between the two of you. Transfers to minor children is an exception to the rule. Transfers to disabled children. If you've transferred your house to a caregiver child, so if you have a child that's been living with you for at least 2 years, and that child has been providing a level of care that has kept you, the parent, out of a skilled nursing facility for at least 2 years, then you may be able to transfer your house, not other assets, but your house, to that caregiver child. And then also, if you own your house with a sibling, and that sibling also has an equity interest in the house, you may be able to transfer the house to that sibling. But very limited exceptions. Again, it's just important to keep in mind that there's that 5-year look back period, and it's if you transfer an asset or your spouse transfers an asset, neither of you are going to be eligible if you've made that transfer within 5 years of needing to apply for Medicaid. And then the last question that I'm often asked is about Medicare notices that a person received when they're in a nursing home. They get a notice that says Medicare is going to stop paying for my care in a nursing home in 2 days. It's a 2-day notice. And I get calls, panic calls, crisis situation where a decision has to be made because Medicare is no longer covering your nursing home stay for a loved one or your spouse, and either you're going to be forced to take your loved one home, and it's often premature that loved one still needs some type of care, or you're going to have to private pay for that care, and you only have 2 or 3 days to decide what you're going to do. So when somebody goes into a hospital and goes to a nursing home for a short-term stay, often Medicare will pay for at least a portion of that nursing home stay. It's the first 20 days are often covered by Medicare. And then after that 20 days, Medicare will continue to pay for 80 days, but only 80%. And then if you have a supplemental health insurance policy, it'll cover for another 20, the other 20%. But you're not guaranteed that full 100 days is going to be covered by Medicare. So that's where that Medicare notice of non-coverage comes in. You get this notice, it says you're not improving, or you're only getting custodial care. You don't need skilled nursing care. So because you don't need skilled nursing care, that Medicare is saying that it's not going to cover anymore. So in that case, again, you're not guaranteed that full 100 days of Medicare coverage, and don't feel like you have to, in signing that Medicare notice of non-coverage, you just have to make sure that you're preserving your appeal rights. There's different options on that notice, and you should read it before you sign it to make sure that you're preserving your appeal rights. And then if you want to appeal, and oftentimes it's a good idea to appeal it, and it tells you right on the notice how you go about appealing it, then at least you know what you need to do and within what time frame you need to appeal those decisions. And with the Medicare notices, it's a difference between custodial care, which is assistance with activities of daily living. So things that are typically seen as non-medical care, often provided by people that don't have professional medical training. And then skilled nursing care is the care that's provided by a professional that needs some medical training or license. So if Medicare is saying, well, we're not going to cover anymore because you don't need skilled nursing care, it's important to look at whether or not the care that your loved one is receiving is really skilled nursing care or not, in order to determine whether or not Medicare should still be covering. So with a lot of the questions that I touched on today, it really comes down to reading before you sign, making sure you understand what you're signing, what obligations you're taking on. And, like any other contract, like any other agreement, you should read before you sign and know what you're taking on. So I don't know if anybody has any questions or comments, but yes, Rich.
Caregiver agreements.
Yes.
Of course, anything paid to the caregiver
Yes.
could be interpreted as a transfer that would mess up the 5-year transfer rules. I'm wondering, first of all, to get when transfers are made or payments for care are made, but there's no written agreement, can you still get that through the Department of Social Services?
Often not. So unless you have a written care agreement that you're being paid under that agreement, then often the state of Connecticut, if they're seeing a payment to a child or a caregiver that's a related party, then it's not going to pass muster, because the rules say that it has to be consistent with a care agreement.
I thought you were going to say that, but I thought
Yeah. And the other thing to note with the care agreement is it's income to the caregiver. It has to be claimed on the income tax returns.
Withholding taxes and all of that too?
I haven't seen withholding taxes. I mean, I've seen, being an independent contractor, the Form 1099, at least with the caregiver agreements, different than an agency or, a caregiver that's you're hiring outside of the family, but it is taxable income. And I have to mention that with respect to the care agreements, I was confusing my terms. So when you transfer a house to a caregiver child under the exceptions to the transfer rules, that has to be a caregiver child. That can't be a stepchild, it could only be a child. A caregiver, I misspoke, and I just want to correct myself. If you're being paid under a caregiver agreement, it's not limited to a child. So it could be other family members. Just want to make that correction.
Okay, thank you.
So now I'm going to turn it over to Dick, who's going to touch on some probate, pre-death probate issues, and then some other things to do after death.
I think it's worth mentioning that Dick has been a probate judge for many
Yes.
but now retired from that position. and fortunate for us that he's with us now.